significant development. The Supreme Court has granted relief to Benazir Heena, the woman who has challenged the constitutional validity of the Islamic practice of divorce known as Talaq-e-Hasan. The top court has accepted her request and directed her to pay 10,000 rupees per month to her husband towards the child's expenses. The court has also passed orders on the issue of father's consent for the child's Aadhaar. In a strong directive, the Supreme Court has instructed the school where Heena sought admission for her child a grant admission, and also it has urged that the child be granted admission without any delay, because in the previous hearing, the bench had expressed clear displeasure over such practices. In fact, the court had also posed a pointed question. Can such a practice be permitted in any civilized society? Talaq-e-Hasan is a form of divorce, viewers, under which a Muslim man can repudiate the marriage by pronouncing talaq once a month over a period of 3 months. And the matter may now be referred to a constitutional bench, signaling a potentially larger reconsideration of this particular practice. And the case was filed by Benazir Heena, who told the Supreme Court of India that even after Triple Talaq, which is instant divorce, was struck down as illegal, many Muslim women continue to suffer because men are now using Talaq-e-Hasan, often irregularly and in collusion with very religious and legal authorities known as the Qazis, because they believe that this particular term, this mode of Talaq-e-Hasan, is now being used irregularly, and that too in collusion with religio-legal authorities known as the Qazis. And according to Heena, this form of divorce has been misused time and again. Unilateral divorces are being handed down without due process, leaving women and children in limbo with no maintenance or support. The procedure mandated under Talaq-e-Hasan also comes under scrutiny. As per law and tradition, the divorce pronouncements must be 3 spaced a month apart, but in many contested cases, the Supreme Court was told that pronouncements are being misused, sometimes bundled together or affected via third parties, for example, via WhatsApp or through a friend, which infringes upon the procedural safeguards. And in a 2017 landmark verdict, the Supreme Court struck down Triple Talaq as unconstitutional, and Parliament later criminalized it under the Muslim Women Protection of Rights on Marriage Act of 2019. And Talaq-e-Hasan may now be the next in line to undergo a constitutional validity test. We have Piyush Pandey joining us on the phone line. Piyush, what are the legal repercussions of Talaq-e-Hasan? And we have reports that many men, especially in the Muslim community, are misusing this particular mode of divorce.
Yes, they are misusing. And today, in a matter of Heena, Supreme Court given a relief to Benazir Heena, and today Supreme Court given an order in a petition of Heena that is related to maintenance of his child, and Supreme Court ordered to her husband, to payment of 10,000 rupees per month for child, and there is a need of Aadhaar integration of consent of husband. So that is a related order in that petition of Heena, and Supreme Court added in his order for a child to admit for admission in the school. So there are several orders in favor of Heena, but as per your question, I hear that is different from Talaq-e-Biddat, but that is a kind of Talaq-e-Biddat that's called Talaq-e-Hasan, Talaq-e-Hasan, and there are many forms of Talaq-e-Hasan, Talaq-e-Hasan. So Supreme Court, considering many of petitions, and after this order today, Supreme Court deferred that matter because many of petitions are not there. So Supreme Court will hear this matter after some time, and that time maybe Supreme Court will direct for constitutional validity of Talaq-e-Hasan and Hasan. Yes.
Right, Piyush Pandey, thank you for joining us with those insights.